Q&A on your Q&A. At the end, I will certainly turn it over and we'll see if there's any other questions. If anybody wishes this PowerPoint, you can email me and I will give you that address at the end. Again, I know some of you have heard this many times, but I keep saying, remember that your client sellers get advice from you. Their consultant, where buyers give your customers, the customers, and you give them information, and you only give them information. I think sometimes we give them too much. Remember who you work for. And again, I keep preaching that you're a consultant, you're an advisor. And the reason we say that now, I think this is much better, and I don't know if some of you have seen this before, but your advertising terms have changed. Real estate broker and salesman agent can now change your name. Broker of record remains the same. So if you are a broker, you may advertise as a real estate agent, a broker real estate agent, a real estate broker, a realtor, or real estate broker. So any of those terms you can use now as a broker. And I like the word agent to the fact, or realtor, that it really tells you I'm not a salesperson. If you're a salesperson, you may advertise as a real estate agent, a real estate salesperson, a sales representative, a real estate sales representative, or a realtor salesperson. You can choose. My only caveat to that is, and I'm sure most of your brokers of record wouldn't say so, but if a broker of record has a policy that you must call yourself a certain particular name, that reigns. I throw you a couple quick slides just to make sure that you use realtor correctly. If you are using realtor, which is perfectly fine, it must be in caps and the R sign because it's a registered trademark. And if you are writing a publication that you're using realtor in it, remember the first word time you use realtor has to be in caps with the R. From then on, all you need to do is cap the R, the rest can be normal, and there's no R required. The only people that can call themselves realtor from this act is people who are involved in organized real estate. Therefore, you are a member because you're a member of the Hamilton, or the Barrie Real Estate Board, and therefore you are a member of CREA, therefore you can use it if you so wish. All right, that was just a little added. Now, I bring this to your attention, the common selling mistakes consumers make according to RICO, and this is what they say. They hire the first real estate agent you meet. They're talking to the consumer now. So this is why it's so important. If you do a proper presentation to your seller, then you're not in competition. If somebody else says, well, we're going to call somebody else, and you go, that's fine, go right ahead. Because I will guarantee you, if you do a good job, you will get the job. Not making your expectations clear with real estate professionals. In other words, the consumer. That's why you need to ask a lot of questions and find out what their needs are as they go on. Failing to read and understand the forms and contracts. I would hope that most of you, to your sellers, we're talking about sellers today, you give them the forms explained. Go to your website, go onto a RIA website where it says forms explained, and they're there. There was 50 some, there's now more of them there for you to use. Don't be afraid. And the other question I'm often asked is, yes, but they're copyright, can we give them to your buyers? Yes, you can give them to your sellers. They're your clients. You just can't put them on a website to advertise them generally, but they are your clients. Allowing emotions to overtake common sense. The other thing RICO says is that your job as a consultant is to try and help with the emotions, to make it sure they understand exactly what they're getting and work with them. Assume everything is included. That is why, Mr. Seller, I'm extremely cautious to make sure everything is writing. The stove and the fridge, if they're included, are properly addressed so that we know exactly what we're getting. Forgetting about what's in the walls, insulation, wiring, plumbing. That's why, Mr. Seller, that we will get likely, if we get an offer, and many times, and this is a crazy market, you may not, but in a normal market, you're going to get likely a clause in the agreement to say they want to do a home inspection, because we're not experts on the insulation and all of the rest of the things to the house. So that's why they're going to bring in a home inspector to make sure it meets your standards. I'm sure it does, but that's to look forward to. Making verbal agreements. In real estate, nothing verbally means anything. So that is why I'm very picky to make sure that your agreements and everything we talk about is in writing to protect everybody. Underestimating selling costs, and I'm going to talk about that this morning. Remember, the bottom line is how much money have I got left when I sell this property to do with whatever I'm going to do with it. So that is why, Mr. and Mrs. Seller, that I need to sit down with you in a great length conversation and talk about all the needs and wants of what you want. What do you need? What do you want? Where are we going? What are we doing? And we talked about that before, demonstrating you're a consultant. I'm a consultant to you. I work for you. I'm an advisor to you. You have to keep telling them that. They have no idea this is what. So now we get into number one, listing agreement. Remember, tips of best use of the listing agreement. The listing agreement is a marketing agreement or an offer to treat by law. In other words, what you put in, you're simply advertising it to say, this is what we would like. But it can change. And that's why it's very important to read things there carefully. Therefore, buyer's real estate agent may decide what information is to be presented to the seller on behalf of the buyer. They will tell you what price they're going to put in. They're going to tell you what clauses they're going to put in. And the other thing that gets very controversial is a schedule. And I'm not sure if you do have a schedule, and that's fine if you do, but if your office has a Schedule B, it's not mandatory because it's an offer for treat. I, as a buyer, sales agent, would go through it and say, we can't agree with this, or we can agree with this. So then when you get it, you have to make sure to read it as a consultant on the seller's behalf to make sure it's in there to protect you, unless there's something that you know. So that's why it's a negotiated process. I hear this statement all the time, a statement such as the broker real estate agent takes no responsibility for the accuracy of the listing information and the buyer agency must verify facts. That's not worth the paper it's written on. I don't know why you waste your time, because you have certain obligations to make sure that you represent the party properly, as well as the buyer salesman. And that's why it changes on every agreement of purchase and sale, because it depends on who you represent. But just to make a statement like that doesn't wash. If you have explained working with a realtor in great detail to do with, then when it becomes time to talk about the representation in the listing agreement, you don't have to re-explain that, other than to reconfirm at the time of the offer is being made. There will be a reaffirmation, because it says very specifically in the representation, I represent you, the buyer represents the likely is their client, I'm your client. If it happens that both of us in our own office put a deal together, then that would be multiple representation. But what it says very specifically is that I will reconfirm that with you at the time of an offer. That's why the confirmation of representation is there, is to reconfirm it. Now remember, reconfirming doesn't mean they can change their mind. This never happens, but my point is this: if they agreed and signed the listing to do and said multiple representation is fine, and then all of a sudden you brought in an offer from somebody else in your own office or your own offer, and they go, well, we can't accept that. No, you've accepted that when you took the listing. All I'm reconfirming with you at the time of the offer with the confirmation representation is that it is a multiple representation or whatever it might be. You always disclose all factual information regarding the property to buyers. You can get sued, so the more you can disclose to them the facts, that's it. I'm not talking about anything else but the facts. Break down the remuneration portion of each party. And I'm sure all of you do that now. But again, remember, prices are up and all of a sudden, they say, this is what happened and this is what the price is. And, if I sell it for $1 million or $500,000, you owe me X percent or 5 or 6%, say 4% just to keep it easy. So that they say 4 times 5, that's $20,000 I'm paying you. And I've often used, and this is an old trick that I'm sure most of you use now, you take 3 coins out of your pocket or your purse or whatever you have, quarters, and show them and say, well, look at these 4 here represent the entire commission. These two here go to the cooperating salesman. And this one here, this quarter here, goes to my brokerage that I work for. So all I have left is a quarter. And that tells me, and then you can explain it further from there, whatever goes on. But that at least is a very visual way for them to understand, oh, you don't get $20,000. And I'm not, you don't have to get into whether you're on a 60-40, 70 split, a 95-5. That doesn't matter. You pay desperate. It's all works out basically the same. Focus on the listing. And I think this is a very good side. The side of the listing portion of what you are going to do, demonstrate the value that you have. And that's why I get paid for this. It's easier to justify the total amount. Office policy may dictate a minimum representative. Your office policy may say that you can list it for whatever you want, but the broker gets 1% or what, 0.5% or whatever it is. And that may be, depends on your policy. And I think this is important though. This is the best statement of all. For all the services I provide to you in the real estate transaction, I charge 2% or 1% or whatever. My only other question as the seller of the property is, what would you like to add on to the cooperating salesman? So I went through all my process. I've told you my needs, what I do for you, the services I provide, my brokerage and I, and for that we charge 2%. Now, the only question left is, as a cooperating, you know, we normally would pay the cooperating salesperson some money. How much do you want to pay them? And you may get into a discussion to that, and it works out whatever it could be. It can be more, can be less. Remember, there's no splitting of commissions. So that, I think, is a good way to go at it, to the fact that you're working and say, for my fees, this is what we get. Now, how much are we paying somebody else? The holdover clause, I get lots of questions on, and stress it to your clients. You know, it only comes into effect if someone was introduced to the property while listed and purchased privately. And that's the whole key, within the number of days stated. So, Mr. Seller, what this simply means is I would never worry about it for you, but I want to explain this to you, that if you, for example, I showed the property or somebody showed the property and it's going to expire at midnight tonight, and you took it off the market and then you sold it to them directly, privately, then obviously you would be owed commission because we introduced them to the property. But if I can't sell your property in the 90 or 60 days or whatever I have it listed for, and it expires, you are absolutely at rights to sell it privately. That's got nothing to do with it. It's only if somebody was introduced to the property. When the listing expires, you can do whatever you want. The words that are important to you, which has changed in our listing agreement, it says any source whatsoever. And the reason that was, it used to say introduced to, and there was always an argument, what does that mean? Does that mean physically introduced to? And with all the social media and websites and such things today, it changes. So now it says any source whatsoever. So in other words, if a buyer, and you'd have to prove it, it's not easy, but if a buyer saw it on realtor.ca long before and never said anything about it and then came directly to the seller, that was likely a source introduced. So that you have to prove it, but that's what it means. Could be by a sign. If the property is listed with another brokerage and sold to a buyer introduced to the property and the remuneration is reduced, the seller is liable for the difference. Mr. Buyer, seller, let me give you an example of that. What I'm saying is that I have it listed at 4 or 5% and everything is fine. And the day before it expires, Martha from ABC shows the property, and Martha shouldn't, but she says to the seller, you know, it's going to expire at midnight tonight. And if you wait till tomorrow and list with me, I don't know what you're paying Hugh, but if you're not paying him, I will do this listing for 2.5%. So wait and list for me. What your list holdover clause says, that if they listed for less money than what you had it listed for, then the seller is entitled, you're entitled from the seller for the difference. And you know, added knowledge, you make sure you give the seller a copy of the listing because the act says so. So ask yourself the questions. Are sellers legally married to each other when you're taking a listing? Is the property being sold as a matrimonial home? And you're asking yourself this. You're not asking them outward. You're just asking in your head. Have all parties signed to give consent to all the agreements? Does the common law partner have property rights? And the answer is technically no. They may refuse to move because of possessory rights. They have possessory rights. Now, not that you're going to get into a battle on this. What I'm getting at, though, is if I go in to list a property and there's 2 people sitting there or 3 people and they all say we live here and we want to sell the property, you take all their names. You know, I don't care if it's common law or it's married or not married. I just want all their names on it. And that's what I said. Do not take the listing until you're satisfied that all parties have signed the documents. It will save you many problems in the long run. I used to get, when I worked at Treb years ago, I'd get calls on a regular basis from somebody saying, well, what do I do now? And I said, what's your problem? He said, well, Friday night I talked to the seller, it's a divorce. And they said, don't worry, get it on the system, get it going because we want to get the property sold. And Monday, when you go over to talk to my husband or my wife, she'll sign. And then I went over to see them and they go, hell will freeze over. I'm not signing any listings right now. So you can't, you got to take it off the market because if I don't have permission from both, and the same thing with the common law partner, I'm not getting into whether they're living common law or they're not living common law. It doesn't matter. But technically, the common law partner is entitled to possessory rights. So the reason I want his or her signature on the listing and on the agreement of purchase and sale is so they move out. Now, in 90 plus cases, 95% of the cases you have, everybody's happy and they move. It's whenever you get somebody that says, now what you have to be careful. So if I went in to take a listing and the wife or husband said, you know, this is our matrimonial, or this is a, you know, but he doesn't live here, or this is common law, and I don't want him to sign it, then you got to be very careful because I need his signature or her signature someplace. Fixtures and channels. This is becoming a big, big issue, guys. I would use Form 823 every time I took a listing, at least bring it out and talk to them. Because what it does is talk about, you know, is the water tank, furnace, water softener, alarm systems, air conditioners, heat pumps, etc., etc., etc. Are they owned? Are they rented? Are they leased? Can you pay them out? How much is it? Are they assumable? All of those things. There are so many things today that are different. For those of you who have been in the business as long as I have, or for many, many years, we knew the only thing that was ever rented before was the hot water tank. Now you have all kinds of leases on the hot water tank. You know, some of them are $40, $50 a month because of the condition. You listen to people, you know, where they're going to get windows put in, their new furnaces. There's all kinds of ways. So use this form. It helps you decide and talks to the seller, and it protects you. Conditional sales liens, and this is what this brings out. And remember, a conditional sales lien can be put on the property without any question about it. And if you took, I think we did this utilizing the registry system. We talked about this if you were on. But remember, when Reliance or ABC or anybody else puts a air conditioner, a water softener, windows in, they come in as chattels and become a fixture. Once they've become a fixture, that gives them the right to put a conditional sales lien in the property, because the person who put that in, the only rights they have are 2. One right is to get paid, and the other is to get, if not, to take it out. Well, they don't want to remove it because it's not worth any money to remove. So they will put a conditional sales lien on the property. So when it's sold, it has to be paid out. And that is why you have to make sure with the seller, and that form will bring up a conversation. And they go, well, yeah, you know, we are paying a part, we are paying something on the furnace, but it's a rent to own. Well, that likely has to be paid, because if I'm a buyer's agent, I'm going to make sure to protect my buyer that it's all clean and liens, you know, on them before closing. So somebody's going to pay them. So talk to them about this. This is so important. Preparing details of the listing. I would use this form also, 820 form residential information checklist. It's a 4-page document, and there's several others on this 820s There's some of you in your country, you are in cottage country, you sell cottages, you sell farms, you sell those kind of things. There's other documents available for the same thing, so go through them if you don't use them. These forms are not signed under any way, so that I'm not going to get into the fact of the SPIS. Many of you don't like that and don't use it because the lawyers will tell you it's not good for the seller. This is a form that you take only with no signatures. You put in your file and you keep it in your file. But I think it's a tremendously good form to be able to, what I would recommend you do, you take a rough copy, you can write on it, whatever, and then laminate it, and you take it out of your briefcase and you say, here's my copy, here's your copy, let's go through these questions together. Because I'm not smart enough to remember to ask you all the right questions to make sure I know exactly about your property and all the needs and wants we want. So I'm going to go through this form and you're going to check it off for me. Please understand, Mr. Seller, this is never going to go to anybody else but me. But at least it brings up questions. You know, there's a section on it when, you know, did the basement ever leak? Oh, yeah, well, it did. Well, now there's a discussion about that. The marijuana stuff today, it asks, you know, has the property ever been used for illegal substances? Well, no, but we do grow 4 plants. All right, that's good. But at least we talk about it. I think this is a good form to get a good conversation. When you're dealing specifically now with water supplies, for goodness sakes, ask the question, is it on water or is it in well? Is it on city water or well? And you're going to get all kinds of situations where you are, because you're going to have them where there's little communities you go through and somebody's going to say, oh yeah, you know, there's city water, but we never put it on. It's on well water, or it's only in the well. You likely know that. Age of improvement. Be careful in stating how old the property is unless you specifically know that. I'm not saying you wouldn't say that somebody says, how old is this property? And you go, I don't know exactly how old it is, but we know the neighborhood is 25 to 35 years old, or it's 75 to 100 years old, or whatever it might be. That's it. But when you say it's 23 years old, you've got to be specific and understand that. Wrong measurements. Do not take measurements from the old listing. And you're going to have that where all of a sudden the seller, you're going to walk into the listing, it's the second time around, and the seller says, well, here's a copy of the old listing. Why don't you just use that? Mr. Seller, I appreciate that. But for me to get a feel for your property and know all about it, we're going to have to walk through it together. And I have to measure it. That's your excuse, because you do not want to. The courts in RICO do not allow and are really not excited. When you go into a court for some reason, or you went into it and said, well, where did you get these measurements? Well, I took it off the old listing. I assure you they're not important. Be very careful of square footage. And I know that most of you now have to put it in your listings agreements. I've always said it's wrong, but that's fine. You put it in. At least clarify it. You know, the square footage is as per assessment, as per whatever. I don't care. Geo warehouse, it doesn't matter. Or as per survey. But for you just to measure it yourself, there's not a standard way to measure property. So be very careful of it. My question is, you know, you put in and say it's approximately, I don't know if you've got approximations or not. And the seller, the buyer will, you know, say, well, what is the total square footage of this house? You go, I don't know. I don't know exactly. If you want, go measure it yourself. So leave the responsibility of the cooperating salesman to measure it. New and updated. I will never win this whole battle, but you should never use the new roof. You should say the shingles were replaced in the summer of 2013. I see all the time, well, it says new windows. Well, the windows aren't new. They're new today and old tomorrow. The windows have been replaced in the last 5 years. That's a true statement. So be very careful what you're doing. Septic versus sewers. Again, ask and confirm if the property is on septic or sewers. You're prudent. Hydro services. We used to have years ago in our listings the amperage, and we took it out because we were being sued. You're not the expert to know what it is. My point is, if from a buyer's point of view, if somebody called you and said, what's the amperage? I'd say, I don't know. When you show the property, show them the box. And if a buyer asked me, what's the average in this property? I'd say, well, the box says it's 200 amp. I don't know, and I'm not an expert. That's up to the home inspector, or we'll get an electrician in, but I don't know exactly what it is. Oil tanks. Oil tanks are becoming a big thing. Owners of oil tanks are not only responsible for damages of the property, but anything surrounding it. So that's why it's important. If it leaked, it's serious. Operational underground oil tanks. If there is an underground oil tank today, propane or whatever it might be, it would have to meet TSSA regulations. I believe, and I can't remember exactly, but I think it was 2015, the act came in very strongly that you had to have TSSA approval if you have an underground tank. They're not that popular today, but they're there. Ask the question, has the seller, provided? If he says, we got an underground tank, well, you say, fine. Where's your TSSA registration? Now, remember, if they say, oh, we don't have any, then I'll tell you right now who would have it is the oil company. So if you can't get it from the seller because he hasn't got it, then go and say, who's your oil company? And you go and ask them, they will provide you certification the oil tank meets its requirements. Are there any unused oil tanks in the premises? And maybe it's an estate and they go, yeah, mom and dad had buried the oil tank, but we don't want to remove it. That's fine, as long as when you sell the property, the buyer knows that and it's written to them, because whoever is in possession of the property is responsible. And we all know that the law says unused residential oil tanks must be removed within 2 years, commercial tanks 1 year. And you can see around the country, you see all kinds of service stations closed. Why are they closed? Because nobody will take the responsibility to pull up the oil tanks and clean the earth. That's why it's a really scary situation. Above ground oil tanks. If you're going through a property and you see that the sellers, and lots of them you have, there's no union gas, there's no gas in the area, whatever, they use an oil tank, and that's fine in the basement. But ask the question, how old is the oil tank? And the reason you're saying that is that maybe it has to be replaced by the insurance company, because the insurance companies are really technical on this. So my question to you, Mr. Seller, is if it's 10, 12, 15 years old, there's a possibility when the buyer buys this property, the insurance company will ask for it to be replaced. Are you interested in helping with that? And he goes, no, we absolutely no. That's fine. At least you understand what goes on. Or they may go, well, you know what, if the price was right, if it's going to cost us, we would be prepared to buy a new oil tank and put it in if we needed to. It's just a discussion. When you sell vacant land, always state the source of the land was obtained, as per deed, as per assessment, whatever it is. I know you are really good at your job, but there's nobody can tell me exactly what 2 acres of land is, or 1.5 acres. So you don't say that. You say as per assessment, it's 1.5, or as per deed, it's 2 acres. That's fine. Always walk the property to make sure you know the lot lines. That will save a lot of aggravation in court cases. In most cases I've ever read, if the people could prove, buyers and sellers, salespeople, if they proved they knew exactly, it was from this corner to this corner to this corner, and it was this, except for commercial, the court said, no, you bought it. So the point is, whether it's 1.78 acres or 1.98 acres, it's a residential lot, and I'm going to put a residential house on it. It doesn't matter, and most of them will say that. Who cares? The back, it's 150 foot back or 140 feet back. Who cares? Because it's there. Now, if it's commercial or you're buying it specific, if you were buying a lot specifically to say, I want to buy, the buyer is building a sixplex, now that's the obligation, and that's where the responsibility changes. The buying agent would have to make sure he put a clause in the offer to say, I'm buying this with confirmation that the property is X size, to make sure that a 4-plex or 8-plex or whatever he wants to do it is going to be done, or commercial. So make sure that. Always start with the concept that there's HST on vacant land, and then prove otherwise. There's lots of property that does not have vacant HST available. on it. There's no question about that. But my point is, you should start with the idea there is HST. If there isn't, great. Because if there was ever used, if it was severed, they ever made money off this lot, it was, it was used for marketing, gardening, whatever it might be, then there likely be HST on it. Farms are completely different. But if it was just a lot sitting there for the last 25 years and nobody ever did anything with it, likely there's not an HST. And there's farms, some people in areas will allow a farmer to sever off an acre of land without HST. So there are lots of exceptions. But my point is, start with the concept there's HST and prove there's not. Renewable energy, I'm not going to go very deep into it today, but if you hit a property with solar panels, wind turbines, whatever it might be, you have to make sure you look at the contracts, because the Ontario Power Authority is going to have to do with it. They're going to have to approve the new contracts. And the other big question you're going to have is, how much is the property worth? Is there, is it, maybe the contract's worth. I had an example a couple of years ago. I sat and talked to the gentleman. He said, my problem is this. I know the contract is worth $400,000 or $500,000. But he said, and the properties I'm going to list are all in the 600,000 range in that area. So he said, if I put $1 million price range on the house, he said, people will ignore it because they don't understand it. So it's a real problem for you, but you have to deal with it. Is the insurance on the property affected by energy installations, everything. So it's really, really interesting. Mortgage details. Does the listing agreement give you, as their representative, the authority to go to the lender and obtain title details regarding the mortgage on behalf of the seller? And the answer is absolutely it does. There's a caution. Clause 10 in your listing agreement says verification of information. The seller hereby appoints the listing brokerage or the listing brokerage's representative as the seller's attorney to execute such documents as may be necessary to effect obtaining any information as foresaid. The seller hereby authorizes and instructs and directs the above noted regulatory authorities, governments, mortgagees to others to release any and all information to the listing broker. So it says that very specifically in your listing agreement. The problem you are going to hit is if you go to the tax department and say, I have authority to get the taxes, they go, our written policy is this. Or I want to go and get a water sample, and they go, well, our policy is this. And you can argue with them, and they may say, no, we don't care. Our policy is this, because you're just talking to somebody that says the policy. So that's why in many cases, when you're talking about sellers with mortgages, the bank, technically, you have the right to go in and ask the bank to give you all the information on the mortgages. They likely won't, because they'll say, we want a signature from the seller directly. That's why you use mortgage verification forms. They were very prevalent, and they're not as good used as much now, but they're very important. I know the interest rates are really low today, but as the interest rates increase and change, boy, there's a whole different ballgame out there. So use it to your advantage. My point is, does the seller understand the penalties, what it's going to cost to discharge the mortgage if he was? If you're going to port it, transfer it from A to property B, that's fine. Is there a cost to that? So there's all kinds of hidden things that you have to know about. A couple examples here. And these are coming back actually very strongly. You represent the seller and you received an offer on their property. Purchase price is $350,000. The deposit is $20,000. And it's conditional on arranging a new mortgage. With all the normal conditions, it's fine. And the second mortgage is a seller take-back mortgage for $100,000 with conditions to protect the seller and such things. So it's all non-transferable and everything else. Everything is good. Because you're selling a property that maybe it's a commercial, a small commercial property. The owner owns the upstairs, he lives in the upstairs and he's selling the laundromat. And maybe it's difficult to get it, but he's quite happy that he'll take back a mortgage, maybe he's getting 7 or 8%. That's more than he'd make on a normal mortgage. So the question is though, the offer is acceptable to the sellers. He likes the price, he likes this. Do you advise him to to sign it? And the answer is no. Because remember, in this situation, the Oklahoma offer It's an Oklahoma offer. You must place a clause, because if you read what I said in the first is that it's conditional on arranging a new first mortgage. Didn't say for how much. So all of a sudden this is Slime Dog mortgage broker they went to, and he gave them $300,000 first. And then you have a second for 100. Now there's $400,000 registered in the property. You don't have much equity in it. So that's why it's called an Oklahoma offer. So you would place a clause in the agreement that either places the maximum to the total deposit or percentage. In other words, all you have to say is acceptable, providing the mortgages never exceed more than 75% of the purchase price, or never exceed more than $300,000. Whatever you agree with, that's fine. But you work for the seller. Read the offers. Here's an example that comes up a lot now, and it's going to come up more as the interest rates go up in price. I know they're very low now, but they won't stay here forever. We were talking this morning that the wartime rates were about 4%, and they're long before that. When I first got into business, my broker at that time said 10% mortgages, you'll never see them below that ever in their life, and they've changed drastically. So they go up and down throughout the years. List price is $320. An offer is presented for $295, with clauses containing a home inspection, plus the buyer arranging a new first mortgage. 10% down, and I just use this as the rate's 4.75, which is unbelievable today. The seller is to discharge the present mortgage. So they're asking that they're going to arrange new financing, and the seller is supposed to discharge. I see that a lot in listings. The seller will discharge mortgages. You have to know what the costs are to discharge it. The seller will only accept, and I put this in just to make the point, the seller will only accept $300,000 as he's not in a hurry, but the buyer can't pay more than $95,000. If you look at the mortgage verification, the interest, and this is a true one, the present mortgage is $279,000 at 2.5. The monthly payments are $900, interest and principal. There's 5 years remaining on the original 7-year term. Penalty to pay off the mortgage, and there's always a penalty to pay off mortgages. And this is normal. 3 months payment or interest differential, whichever is greater. So many people say, oh, don't worry about it, we'll just wait. Well, all of a sudden they find out they have a $270,000 or $250,000 mortgage, and it costs 3 months interest on it, and the interest rate, they took it out at 1.84%, but the interest rate now is 2.5%. Well, 0.75% on $250,000 for 5 years is a lot of money. So the point I make in this one is the interest penalty is $6,000, or if the new mortgage is obtained with the same lender, it's only $300, because mortgage companies and the banks, they want to get the money back out. That's where they make their money. So what they're saying to you, and this is the same as it is today, and I've checked with mortgage brokers this a lot. So in other words, the interest penalty is $6,000. So you would say to the seller, even if I got you $300,000 in round figures, for you to pay off your mortgage is going to cost you $6,000. So you really only got $294,000 for it. Mr. Buyer, if you go to the TD Bank where this mortgage is now written and get that, it'll only cost, you can do that, and then Mr. Seller, all it'll cost you is $300. And that is true, but the point we make here is you must put it in writing. And the mortgage brokers I talked to warned me of that. They said, we will not take a verbal, oh, well, yeah, I agree, I'll go to the TD Bank, and then they say, no, we're going to the Royal. Most buyers don't care where they go as long as they go where the best deal is. So these are things you have to look at. Can she afford to move? This is a true example. The property not far from where you live, where I'm talking to you today in Barrie. A property owner would like to sell her present property and purchase another one. The owner makes close to $160,000. When the salesman said, I thought I died, got to heaven, this lady makes big bucks. He observed there was a 14-foot motor in the driveway with a luxury car. In talking to him, the real estate agent took all the details of the property, and they got permission to go and talk to her financial status at the banker. Now, they discovered the property was worth about $300,000. It would sell. There's no question about it. And they would get paid and she could move. But the problem was, as the seller, the bank warned them, is that her mortgage, her credit cards were at max, her car was a lease, and she had no money left. So if she sells her house, she will never buy another property until she pays off all these other debts. So what was the advice? And I agree with this, and I would do the same thing, and I have done it. You know, you go back and say, you shouldn't be selling your house today. Get rid of your credit card limits, maximums. You know, look at leasing your car, and then we will sell your house because you'll have equity left. But right now, you have no equity in your property. You're going to hit that a lot in the next 2 years. So remember, most sellers focus on value. How much money have I left? And this is a very, very simple, and I'm sure all of you have one of your own. But all I'm saying is, when you sit down and talk to the seller, they want to know what's the bottom line. If I sell my house for $650,000, how much money have I got left to do with whatever I'm going to do? Is it 300,000, 400,000? Is it 50,000? Is there zero? So that's why you work this through, you know, disbursements, adjustments, lawyers' fees. And again, you don't have to figure it out exactly, but you would put in, you know, lawyers' fees are going to be 2%. You know what your lawyers are charging in your area. The mortgage payout penalty is maybe nothing, or it may be at $10,000 or $20,000. I know of people, mortgages that were $20,000, $30,000 penalties. My fees. So this is what the total we have left. So look at those. See. Number 5 we talk about is lock boxes. They have changed a lot in the last, whatever. I honestly don't know. I should ask Danielle if you have electronic lock boxes in Barrie or not. I can't remember. You do or you don't. If you do, that's good. But RICO on June the 15th, 2018 made it come out very strongly to say that you must tell your sellers the advantages and disadvantages, and you must have consent in writing for them, for you to put a lockbox on the property. So that's very, very important. So Form 208, some of you may have known this form as 108, but it's now 208, was developed for this reason. The seller acknowledges and consents to the entry of the above property for the following purpose: for showings. And the date of entry is today until it expires. And the brokerage represent to be present during the above entry access. Who's going to be present? The listing broker or the cooperating broker, and they're neither. Now, maybe they don't care. Maybe it's a cottage and they said, we don't care if anybody's there. Let the buyers go direct. I doubt that's going to happen. But that's what I'm saying, is that's why it's there. And the big thing is, this clause says the seller further acknowledges and consents to the entry access of the property by means of keys or other devices in a lockbox, and the seller understands and acknowledges that benefits and risks associated therewith have been explained. So you have explained it and they signed it. Now, if you don't want to use this form, that's fine. Put it as a schedule to your listing agreement, but make sure it's something wording of this nature to protect you. So tips of using a lockbox. Lockbox should be placed on the property, not on somebody else's property. For instance, we throw them often on the union gas meters. They technically shouldn't be there. They should be on the property. And I understand this is a problem. Some places you get condominiums where there's no place to put them. You have to put them on a fence or whatever. I understand that. But you should try and put them on the real property. Do not give the keys to another real estate agent. And if you are electronically inclined, that's good, because you've elected put it in and elected put it out. So if I was showing a property and somebody knocked on the door, or I come out the door and they said, oh, here, we're going to show the property now, just give me the key, I'd say, you know what? I can't do that. My broker of record is really tough on this. I'm going to have to put it back in the lockbox and lock it, and you can absolutely get it out, because you don't want to take responsibility to give it to me and I take off with the key or I lose it. Or more than that, you don't know who I am. I've got a card, but that doesn't mean anything. and I'm a scammer, and I'm just going in there to see if I can wreck the place because I am learning how to do this. I just follow real estate salesmen around. I show up at the door when they're coming out and say, "Oh, I'm a salesman. Can I come in the property?" And I go in and I take it all out, and they disappear. So do not give another real estate agent a key. Put it back in the box and have them do it. If your seller says, "Well, I have a keypad, it's 5524 to get into the property. What do I do?" Then take that, write it in the lockbox, in your card on your lockbox, and close it. So you don't give it out over the phone. You don't say, "Oh, well, don't worry about it. Just push 5524. Then he gives it to everybody, writes it down. Who knows? You want to secure it. Here are some suggestions how to deal with the seller. RICO, Mr. Seller, I want you to know the consumer protection body who works for you, technically as consumers, require me to discuss the use of lockboxes with you. This is law. I have to do this. I will make every effort to limit the possibility of unauthorized access. Only real estate agents that are registered will be given permission to enter. Any third parties, appraisers, home inspectors will be accompanied by real estate unless otherwise agreed upon. And that is very true today. And I'm going to show you the entry access, and you can use it too. But if you get a offer from a buyer that's on a home inspection, I would use 208 and pull it out and write it in to make sure that the buying salesman and his buyers, if he so wishes, and are accompanying the home inspector. The long and the short is very simple. No one who's a third party will enter a seller's property without written permission. So don't get caught with it. Many of the cases that went to RICO this year are all over this. The access code should be changed on a regular basis. If you're electronic, it's not a problem because it changes. If you're using a combination, change it regularly. Every 2 weeks or once a week, change it. Because I don't want somebody going that showed it today, go back 2 weeks from now and use the same combination to get back in. They need permission. The lockbox is always placed in a secure place. You tell them that. And the code is only given to real estate agents that I or our office can identify. So if somebody calls me and says, I'm so-and-so, then no, if we don't have record of it. The cons, there are cons. The lockbox may be broken into or gain access to the property. That's no different than somebody could break into your house tonight. I can't control that. An unauthorized person could use a lockbox code or give it to somebody else. I have no control of that. If I found that out, Mr. Seller, I would certainly be reporting to RICO for disciplinary hearing. Occasion lockboxes may be improperly closed. I can't control that, so sometimes it's it. But remember, I need to get written permission from the sellers. There's quickly 2, 3, 4, 5, 38, 39, 41 are the codes of ethics that the RICO will do. Unsupervised entry, Chris, this is true. Chris, the listing agent, gave Kara, the buying agent, the lockbox combination to show the property. Chris discovered that the buyers accessed the property without Kara being present. Chris complained to RICO. Kara, in her defense, stated that she understood exactly what she should have done, but because of traffic, she got tied up, and they walked in on their own, and it cost her $5,000. And as I said, if you read a lot of the RICO hearings today that went on in 2020, were all based on this unsupervised access. As I said to you before, this form I would use if I was going to give somebody an appraiser or a home inspector or is going to come in, I would give it. I hear this all the time. The bank just calls the listing agent and says, well, what's the combination? I'm going to send my appraiser. You better be there with them then if you're doing that, or make sure the buying agent, nobody, an appraiser. The only exception is if the appraiser or the home inspector is a member of your board, a registered member of your board. Number 6, power of attorney. I'm going to move on here. I'm going to run out of time. Power of attorney, there's 2 kinds of power of attorney. The power of attorney for property, which handles business and financial affairs. And there's power of attorney for personal care, and you know that. which is to do with personal care. It's called a living will. All I'm saying to you is somebody may say to you, oh, I've got power of attorney for mom. Well, you better make sure it is power of attorney for property, not power of attorney for personal care. And the other thing that is extremely important to remember is people will say, well, I have power of attorney. My mom passed away last week, and we would like to, like to get an idea for the property and whatever enlisted with you, the estate. Once power of attorney dies, the minute the person dies. So wills must replace the asset. Now, that may be the same person. I don't think it's not. But if John is the power of attorney and mom dies today, power of attorney is dead. And as a result, we have to deal now with the executors of the will. Questions you need to ask yourself: has the person signing the agreement been granted power of attorney? Is the power of attorney restricted or limited? Again, you want to, that's why we're get to the point you should ask for it and see it, because maybe it's restricted. Maybe it says you could have sold the property, but only from this point to this point or for whatever price. Does the designated attorney have the authority to execute an agreement and bind the grantor or the grantor? So is it a binding power of attorney? Does the power of attorney specify the means to determine whether they're incapable or not? And some of them do. That they have to know they're incapable, because that's the only time a power of attorney comes into effect, is when the person who you're acting for is not capable of making decisions. If they are, they have to make the decisions, and that's a tough job, and that's in another course I cover it more. This is important. Has the real estate transaction document been properly executed? So in other words, if it is a true power of attorney, remember the listing, the owner of the house is Jane Smith. Therefore, it has to be taken in Jane Smith's name. And you may put in a POA Mary Black. You don't have to, but at least it's Jane Smith who owns this property. But when it comes time to signing the documents, it's Mary Black, who is the power of attorney, signs as POA for Jane Smith, because Jane Smith can't sign. Has the original or copy of the power of attorney been attached to the schedule? I would ask for it. Again, you have a friend that says, I have power of attorney for mom, whatever, and you go, I understand that, John. I know we're buddies, but my broker of record is really tough on this, and he needs a copy. So I need to get a copy from you, or I need to go to your lawyer and get a copy. You need proof. Because is it possible that power of attorney is terminated because of death? But more important than the proof, you want to accompany it and attach it to the agreement of purchase and sale. Because I guarantee you the bank who's going to give the buyer money will want to know it's true power of sale. Because they're going to say, how do we know this is legal? HST, number 7. If the sale of the property is subject to HST, then such tax shall be included in addition to. You must read clause 7 very carefully for the purchase price. If the sale of the property is not subject to HST, the seller agrees to certify on or before closing. So he has to certify it's not subject. That's part of the closing deal. And that the sale of the property is not subject to HST, period. And that's what he has to declare. But chattels, if applicable, do not include it in this purchase price, because that is a whole separate entity. And normally what the lawyers will say, the fridge and stoves included, they're worth $2, and then we'll put it through. But that's not to do with this. So the question is, what type of property is HST paid? Residential resale? Likely no. Commercial property? Absolutely yes. A rental unit over 6, or rental units over 6, and the answer is no. People believe that anything over 6 units is HST-able. That's not true. I can sell 100-plex of complete rentals, and it's not HST-able. Office in the basement, that's yes and no. And this is going to get more complex for you as we get into with so many people now working from home. And there's a very complex question. So again, likely not, but it may be if they declare it and depreciate their property and all of those types of things, then it may be. But it's a completely different thing of me working alone from home and working on my own as an independent contractor than me as a business who my company send me home to work in the basement. That's whole two different stories, and you really need clarification on that. But a commercial business, hair salon is owned, owns the house. You're going to get more of that because people can't afford, the rents and such things. And my wife's hairdresser announced to her a couple of weeks ago that she will not, once her lease expires in the new year, she's moving to her home to do her business. Well, now that part of the house that she's using will become a commercial business and will become HST-able. If the buyer and the seller, and I keep asking this question, and I know it sounds repetitious, but if the buyer and the seller both have HST numbers, how should clause 7 in the residential agreement be completed? Now, technically, if they both have agreements or both have HST numbers, it's a wash through, right? We just sign papers because you never pay HST until the end. But it is. So all of a sudden, if the buyer and sellers have HST numbers and the agreement was completed with included in, and many buyer and salesmen will just put that in anyway, included in to protect them, because they're saying if there's HST, that's the seller's problem. Now, in this example I'm using, the buyer and the seller both have HST numbers, and we just said it's a wash. In this case, when it says included in, it wouldn't be a wash. And here's what's going to happen, and I make it very simple. It's a $400,000 deal. 200 is commercial, 200 is residential, and the seller gets $374,000 because I guarantee you the buyer's lawyer will subtract 13% from the purchase of the commercial part of it and deduct it. And then the seller's going to call you and say, I thought we sold it for this. And you go, well, we made a little mistake in clause 7. And he goes, no, we didn't make a mistake. You made the mistake. I hired you, you'll pay. And this happens every day. So read the conditions, make sure you understand the HST process. This is a true scenario. I talked to a salesman, agent, this is 6 months ago now, but he was telling me, I couldn't believe it. The buyer's real estate agent submitted an offer indicating clause 7 that the HST was included in. He knew exactly what he was doing. The selling real estate agent called the buying salesman a short time later and said, we have an accepted offer. When the offer was returned by email, the included in was changed to addition 2. No initials, just changed. When the buying real estate agent inquired regarding the change, the seller claimed, he said, well, you made a mistake, Mr. Buyer or salesman, that you put it in, so I just tidied up the offer. No, that we don't have an offer. There's no initials on this. So read carefully. Number 8 is importance of internet. Explain to your sellers the importance of the internet. Why was Realtor.ca changed from MLS.ca? Because people believed that MLS was the MLS system. That's what Realtor.ca was, when it's not. Remember that Realtor.ca is a completely an advertising function. That's all it's for, is to advertise. It's a good advertising function because there's no commercials on it, and no, they don't sell any ads. So when somebody goes onto it, they simply see the properties. That's good for you. How popular is this site? You should be able to tell your sellers, and before I took a listing, I would hope you went in and said to the sellers, I'm going to put your listing on Realtor.ca. Everybody does it, but I'm not going to tell them that. I'm just going to say, I put it on Realtor.ca. And I want you to know, according to the stats, and you can do that, is last month there was 6 million hits or 8 million hits in the whole thing. There's billions of hits. All you have to do is go to member.realtor.ca, look up Realtor Insights, Realtor.ca Insights, and you can have the overall stats. It'll tell you the number of hits per month, years, etc., etc. So use this to your advantage. We do not talk about this enough. What's the difference between Realtor.ca and MLS system? Again, you just simply say, I put it on MLS. It's two separate systems. So Mr. Seller, when I take your listing, I do two things automatically. I put it on realtor.ca and it's advertised and this is the results and this is whatever. But secondly, I put it on the MLS system and we have in Barrie, 987 salesmen and they all want us, so I want to get your property sold as quickly as possible. That's two things I do for you. Can you give the sellers the number of hits that have been put on the site? Yes, you can. Again, go to the member.ca and look up the listing stats. Now you use that both ways. After 2 weeks of it being listed, you look at it and go, nobody is looking at your property. Or we've had, so therefore, what can I do? Or we've had 100 people look at it and nobody's coming to see it because they must think it's overpriced or there's something wrong with it. So use these stats to your advantage. How does DDF, the data distribution function, assist the sellers? Again, do you explain that to them? When you take a listing, Mr. Seller, I take the listing and I put it on realtor.ca as well as MLS.ca. I put it on realtor.ca. And we have a system called DDF, providing your broker has applied for it, and I'm sure most of them have. What it does is said, when it goes to realtor.ca, there's about, and you can look it up again if you go to member.ca under the DDF and it'll tell you exactly who it is. There's about 15 though, different websites. So automatically when it goes to realtor.ca, it also goes to these other 15 websites daily. But the advantage is this has over a lot of other websites is unfortunately when it goes onto another website, they get on there forever or they don't change the price and it's a real problem to get them off. This is a system set up that they have to come back every day and update your listing. So if you changed your listing price or you change something in the data, they will take that data and it comes up. So in other words, all of these other 15 websites are up to date with your listing and they know exactly what it is. So that's another way I advertise your property. Do you tell them that? So tell them all these things. The other thing you should do, and I got to take a minute to do this because it's important. When you do a CMA for the property and tell them this is what it's worth, and that's exactly right because you used 3 or 4 properties in the neighborhood and it was exactly the same and that's ideal. But what you have to say to them also, and I would look at this, is when you go into in the Barrie area, look on realtor.ca and look and you say the price is going to be, I'm going to propose to them it's worth $490 to $500,000. I just use that as an example. So what are we going to get this? And you say, well, I think we should list it at $499, and I think we'll get between $490 and $499. And I understand the market is nuts today, like it is all over the place. That's nothing, but in a normal market. And so what I'm saying is, I also brought you a list. There are in Barrie area under realtor.ca in the $490,000 to $500,000 range. Here's a list of 70 other houses or 100 other houses in that price range. And why is that important? Because remember, Mr. Seller, when people start to look and they say, we're going to come into Barrie or we want to look in the Barrie area, they're going to look generally to start with. They're not going to zero in on your area. Your area may be the best, but they maybe just know Barrie, a district. So they put that in and all of a sudden there's 600 properties come in. So if we list your house too high, and they're going to have a maximum of $500,000, they may never see it. So you have to tell them this and show them this reason. Offers received, number 9. I'm going to go through this very quickly. I think I did this with you before. Remember, it's for offers received, not multiple offers. If you have a listing and you have 12 offers on a property before it's sold, you better have 12 pieces of paper showing them that there was there, whether it's agreement of purchase and sale or an equivalent form, which is 801, and they're big problems. Now, the other thing to remember too is when you ask them for a copy and you have the agreement, once you have the agreement in your hands, the agreement is yours to do with whatever you want with until you're done with it. You can't have a buyer agent say, well, I'll present the offer and then I'm taking it back. No, you're not. I keep it. So once you've emailed it to me or sent it to me or presented it to me, it's mine. It's your listing to keep until you're done. Retention of offers is not a big deal. Form 801 is used as evidence of a signed offer. If you have an example where all of a sudden they call you, and your offer may be very true, they call you and I called you and said, I have an offer on the property. Your question may be, is it signed? And I go, no. And you go, well, then we don't have an offer. Or if it is signed, I want proof of it being signed. That's why you would send me an 801. I, as a good buying agent, would not send you a copy of my agreement of purchase and sale. If I do, that's fine, but I'm a little crazy. Remember, this is not a mandatory form. You can't demand the 801. I can send you an email to say I have a written agreement, but when you get the offer, you can keep the agreement of purchase and sale. But I can't demand you send me an 801. The most important thing to remember on this is the 801 is it's a one-way agreement. When you receive it as a listing agent, it never, ever, ever, ever leaves your hands. No exception to that. And people send it back all the time, but you don't. Because there's only three things can happen to any offer. It's either accepted, it's rejected, or countered. If it is accepted, we're done. We keep a copy and do all the paperwork. If it's rejected, I need proof that it is rejected. So if they want their agreement of purchase and sale back, that's fine, send it back, but I keep the offer document. The big one is counter offers. When you counter the offer back, if I brought you an offer and you countered it back to me, you don't know if my buyer's going to accept. I don't know either. You know, the buyer's going to accept the counter or he's going to counter the counter. We may do this 4 or 5 times. My example is if you and I were battling over this for 5 times countered, then I have 5 different offers. Every time an offer comes in, a counter offer is countered, it's a new offer. It's not the same offer, not the original. So that's why you never give it away. So what I do as a buyer's agent, I fill that out. You then would fill in the bottom part and sign it, put it in your file and forget about it. Remember, the seller never signs anything. It's got nothing to do with the seller. This is to do with phantom offers. Did you present the offer? Now, if it's a counter offer, what the buying salesman has a right to do, they can either send you back the original as whatever, or they use the bottom part where it says for the buyer to counter offer, complete the following forms. The buying salesman simply pulls it out of his briefcase. The buyer signs it. They write their name in and they send it back to you. That's why you do that. So it's all there's to it. The last one we talk about is consent to advertise. This is new, important to the following questions. The listing agreement, and people say that, but in clause 6 in your listing agreement, it gives you permission to market. How you show the property, you can put a for sale sign on the lawn, you can put a sold sign on it, you can advertise the property, etc. Clause 11 in your agreement of listing agreement says that's the use and distribution, and that's to do with privacy. So it's consent to the market, gives information. You can Mr. Seller, whenever we sell your property, I can put it on the MLS system. And the reason we do that is because that's the way we can do comparisons. And they go, well, I don't want to put it on the MLS system. I said, well, unfortunately, that we have to do that. Because when I came to take your listing, how did I know to price it? Because I used comparisons that were on the market today. Because in 6 months from now, they may change. So that's what it's for. Buyer representation is 8, use and distribution. But none of these clauses give you permission regarding the sale price. So your Code of Ethics, Section 36, and there's others, but this is the main one, advertising says, a registrant shall not include anything in the advertisement that could reasonably be used to determine any of the contents of the agreement that deals with conveyance of an interest in real estate, including any provisions of the agreement relating to price, unless the parties agreement having consented in writing. Sorry. So therefore, there was a complaint and it cost them $10,000. So you have to get it in writing. There's nothing wrong with RICO or under REBA 2000 of advertising and providing you meet the guidelines. You can advertise anything you want, providing the buyer and the seller give written permission. It should not be in the agreement of purchase and sale or schedules. And that's where a lot of it is today. It shouldn't be there because, first of all, the agreement of purchase and sale is between the buyer and the seller, not you. And the other reason it's really dangerous is you represent the seller. And I, as the buying salesman, put in a clause to say, I want to advertise that I sold this property. The seller looks at this and says, I like the offer. It's exactly what I want, but I don't want the buying salesman, anybody to know what we sold this property for, other than those that have to. So I don't want him to advertise it. But if I stroke out that clause, it technically is a counter offer, and vice versa if you wrote it in. So it's very difficult. Sold only covers the use and distribution. Anything to do with price, percentage of sale, et cetera, must be a separate document. That is why we have now Form 170, the consent to advertise. And it's a really good form because what it says is, yeah, I'll let you advertise the sale price. Anything identifying the sale property or identifying the property. If they both, the buyer and the seller, initial it, or any terms, whatever you want to do, or you may put, say, this only can be advertised for 30 days or 20 days or whatever it might be. You can do that. Now, again, as a buyer's agent, I could bring this with you when I bring the offer, and I could ask this to be separate. It's not attached to, it's not part of, but it's a separate document. Or I could wait until it's all over and maybe you do a firm deal up and the seller says, and you say to the seller, I'd like to advertise your price. And he goes, well, okay. And so you would then send a consent form the other way to the buying salesman and ask him, to the buyer, to sign it and give you permission to do that. But both parties must give written consent without. Thank you, ladies and gentlemen. I ran a little long, but I hope it was worth it. And so if you want to email me anything, it's hughfoy46@gmail.com. I would be more than pleased to answer any of your questions. And I will be coming back on the 23rd of November to talk about should I incorporate. That's another fun, that's a shorter webinar, but that's what's going on. So again, Hugh Foy, HUGHFOY 46@gmail.com.
Thanks, Hugh. That was awesome.
If anybody's got any questions, we'll answer them. If not, we're all done. Go and enjoy your day. Okay, that's great. Thank you, Danielle.
No problem.
We'll talk to you soon. Have a great day. Bye-bye now.
Bye.